Hello, I am Luiza Sato, partner of the cybersecurity and data privacy of the Brazilian law firm TozziniFreire Advogados. You probably know by now that the risk of non-compliance with privacy and data protection laws may result in severe negative consequences in M&A transactions. Because of that, agreements must provide for strong representations and warranties that I'll be fondly referred to as REPs to be given by the seller to the buyer. I will briefly speak about the purpose of the REPs, the risks they aim to address, and their main or most usual content. As to the purpose, REPs are used to frame the liability of the parties in the M&A transaction. They are key to assure the truthfulness of facts declared by the companies and the compliance of actions by such companies. REPs can be used by the buyer to cushion potential privacy and data protection breaches committed by the target. And the most common risks the REPs aim to address are the following three. Number one, contingencies involving privacy and data protection matters, for example, data breaches, violations of data subject rights, and lawsuits. Number two, blind spots due to insufficient knowledge of the target's data flows and processing activities. And number three, data protection compliance that actually exists only on paper and not as a living and evolving element of the target's internal practices. As to the main or usual content, that should be, of course, tailored on a case-by-case basis, and the REP should cover one, compliance provisions, meaning the obligation for the target to comply with the applicable laws and regulations on privacy, their own privacy policies, agreements with customers, consents given by data subjects, statements provided to regulatory bodies, and other commitments. Two, adoption of measures to ensure compliance with laws, regulations, agreements, and other commitments to guarantee a certain level of information security and to undertake that vendors and data processors also follow a certain level of data protection compliance. And three, hold harmless provisions regarding past, pending, or threatened claims, actions, disputes, or complaints regarding the processing of personal data filed by individuals, administrative authorities, and third parties.